Rules Committee will come to order, and thank you very much for joining us this afternoon. Today, the Rules Committee will consider two bills, H.R. 527, the Small Business Regulatory Flexibility Improvements Act, and H.R. 50, the Unfunded Mandates Information and Transparency Act. H.R. 527 would provide much-needed reforms to Regulatory Flexibility Act of 1980 and the Small Business Regulatory Enforcement Fairness Act of 1996. The bill is really quite simple. It's a common sense mandate for the executive branch to work together with small businesses to design and make smarter with less rules and regulations and things that are burdensome and hindrances for employers to hire more people to keep the American workplace smart and active and prepared. H.R. 50 would amend the Unfunded Mandates Reform Act of 1995 to inject additional transparency, accountability, and public awareness of new federal rules and regulations. This bill is important because it would yield more effective and efficient regulations designed to avoid unintended consequences and to tailor regulations to solve legitimate problems. Today, we will hear testimony on H.R. 527 first. The gentleman from Pennsylvania, Tom Marino, and the young chairman of the Small Business Committee, Steve Shabbat from Ohio, and Congressman Hank Johnson from the Judiciary Committee. After that, the panel will hear testimony on H.R. 50 from Chairman Jason Chaffetz from Government Reform, Congressman Mark Meadows from North Carolina, and Congressman Gerald Conley from Virginia from the Oversight and Government Reform Committee. I also want to thank the gentlewoman, Dr. Fox, the Vice Chairman of the committee, for her leadership on H.R. 50, which she has introduced in the House of Representatives and is the main co-sponsor for this activity. I want to defer to the gentleman for any comments that he would choose to make. The gentleman has welcomed our witnesses that are here today. I would also welcome the young gentlewoman from Texas to be a part of this panel as she chooses. I know she's a part of this testimony about Small Business Regulatory Flexibility Improvements Act of 2015. Mr. Marino, thank you very much for being here. Mr. Chairman, thank you. Hank, I'm delighted that you're here. Obviously, you know that you represent not only your committees of jurisdiction, but also your party and many people who have an intense interest in job creation and getting things done. I know there's a strong disagreement, as we even disagree about how great states are up here. But I've worn my Texas flag today, my tie, to let us know that I will stand for what I believe in, and I'm sure others will do the same. Steve, I see you've got your tie on. Good. Well, we're delighted that you're here. So without objection, anything you have in writing will be entered into the record. And is it full of snow? It's hard to get to it. By the way, congratulations. Victory well earned. I watched Tom Brady in that with whatever a second left, and he was elated too.
Good things happen in Massachusetts.
I could tell. Well, congratulations.
Thank you for the, I'll pass it on to the Patriots when I see them. Thank you.
Yes, sir. Mr. Marino, you're welcome to the Rules Committee on a bipartisan basis. We're delighted that you're here, and gentlemen is recognized.
Thank you, Chairman, and thank you, members. I would have worn a special tie that I wore as a prosecutor when I was sentencing people. It was a Three Stooges tie, but I probably should not wear that here. But I would ask that unanimous consent be granted that my full statement be made part of the record. I'm going to skip the first several pages because it's a historical background. Okay. The regulatory burden hits small businesses particularly hard across America. Small business generates 60% of the net new private sector jobs and employ nearly half of America's private sector workers. Yet they have to pay significantly more to comply with federal regulations than do larger employers. And they rarely have in-house legal departments or regulatory compliance experts to help them. This is not fair. It is exactly the wrong burden to place on America's small business job creators as this nation struggles to produce a true jobs and wages recovery. In 1980 and 1996, Congress enacted laws to try to force regulatory agencies to better account for and minimize the unnecessary burdens of new regulations on small business. Those laws, the Regulatory Flexibility Act and the Small Business Regulatory Enforcement Fairness Act, have regrettably failed to achieve their potential. They contain too many loopholes. Their interpretation is too inconsistent across federal agencies, and they do not give small business enough early opportunities to be heard in and affect regulatory decisions with better ideas. The bill before you today, H.R. 527, closes those loopholes. For the first time, authorizes the Small Business Administration's chief, Counsel for Advocacy to be the one consistent authority on regulatory flexibility requirements the law imposes on agencies. It requires agencies to assess not just the direct effects of new regulation on small business, but also indirect effects, which often can be substantial. And it mandates that all agencies engage in small business review panels early in the rulemaking process before agencies become entrenched in their proposed path to help small businesses better and more effectively point out to agencies what is the best path. The minute this bill becomes law, what will start to happen? Well, small businesses will have a real chance to be heard before agencies effectively make up their minds. Agencies will have better information upon which to tailor their regulations to reduce unnecessary burdens on small business. Agencies will have fewer opportunities to escape requirements, to hear those businesses, and gather that better information. And small businesses will be freer than they have been in decades to devote their resources to what they do best: create the new jobs and innovate the new products and services that can drive this economy forward to true and lasting recovery. H.R. 527 brings urgently needed regulatory reform to hardworking Americans. I respectfully request that the Rules Committee grant an appropriate rule that allows for expeditious consideration of H.R. 527, and I yield back the remainder of my time.
Thank you very much, Mr. Marino. I appreciate that very much. Now, the bill sponsor is the gentleman who has long been an advocate for small business, job creation. And Mr. Shabbat, I'm delighted that you're here. Gentleman's recognized.
Thank you very much, Mr. Chairman. I appreciate the opportunity to appear here before the Rules Committee, and I would concur with all the comments made by my colleague from Pennsylvania, Mr. Marino. This legislation addresses a goal shared by both Republicans and Democrats, and that's the need to craft more cost-effective and less burdensome regulations without undermining an agency's ability to protect the public. H.R. 527, the Small Business Regulatory Flexibility Improvements Act of 2015, will help agencies achieve this sensible regulatory approach by modernizing the Regulatory Flexibility Act, or RFA. The RFA requires agencies to assess the impact of their regulations on small businesses. Really kind of a common thing if you think about it. If the impacts are significant, agencies must consider alternative approaches that would impose lower burdens on small businesses while still permitting the agency to achieve its regulatory objectives. There would be no need for this legislation if agencies complied with the RFA's common sense requirements after amendments in 1996 and presidential directives, but the agencies do not in many cases. And H.R. 527 closes those loopholes that allow agencies to ignore the RFA. It forces agencies to assess both direct and reasonably foreseeable indirect effects, provides for early input in the regulatory process by small businesses, and seeks to reduce litigation by requiring the Small Business Administrative Chief Counsel for Advocacy to write government-wide rules for compliance with the RFA. It's important to note, and despite what some opponents claim, that the bill never stops an agency from issuing a rule just from it does not consider the impacts on America's small businesses, which, after all, provide a means for millions of workers and their families to get ahead in life. H.R. 527 includes 8 Democratic amendments the Committee on Small Business adopted in the 112th and 113th Congresses. So there has been considerable Democratic input in this bill. It is identical to the bill the House passed twice last Congress and very similar to the bill that the House passed back in the 112th Congress. Given this legislation's long history and the opportunities that everyone has had to offer input in the past, I believe that a structured rule is the most appropriate way to consider this bill on the House floor. I want to again thank all of you and would be happy to answer any questions that any members might have.
Mr. Chapman, thank you very much. Ms. Jackson-Lee.
Thank you very much, Chairman, and to the ranking member of the Rules Committee. I think there's an important point that I'd like to make. First of all, that we all come with a commitment to small businesses and looking forward to working with them to ensure their prosperity. And I just want to make this simple point that H.R. 527 seeks to relieve small businesses of the burdens of the RFA or the regulatory scheme that's in place. But it's important to note, rather imposes numerous and unnecessary burdens on agencies while ignoring the fact that small businesses, like their larger counterparts, can substantially impact the health and safety of their workers as well as the general public. Make the point that if you are getting poor air, poison water, and other hazards, whether they come from small or large businesses, they are impacting the public in a negative way. My amendment seeks to remind us of that important point, and it seeks for rules from the Food and Drug Administration, commonly known as the FDA. The Small Business Regulatory Flexibility Act adds a host of new analytical requirements for agency policy actions, including rulemakings and guidance documents that might affect a large number of small businesses, even if that effect is indirect. And because the bill defines indirect effects broadly, it would mandate costly and wasteful new analysis that could be applied to virtually any agency and action, any action an agency attempts to undertake, no matter how tenuous the connection to small business interests. We know that we live in a very challenging atmosphere. Certainly, many of us have had our attention on the outbreak of measles. We've called upon the FDA and the CDC to respond to that. We may have not heard of the condition of CRE, which has affected a particular medical device that has caused the passing of deadly germs and has caused the attention of many hospitals. It is life-threatening and may require some action by any number of agencies, including the FDA. My amendment asks for an exemption for the FDA for that very reason, to be able to move swiftly and expeditiously for the public safety. We know that agency to have that responsibility. Mr. Chairman, ranking member, the economy is doing fine now. Not every single American has been improvement. A bill like H.R. 527 only serves to gum up the wheels of government and business collaboration by creating new and confusing rules. I know there have been efforts that have been bipartisan, and I respect and congratulate the individuals who are the sponsor of this particular legislation. If that is the case, I'd ask that my amendment be considered as a bipartisan effort to make sure that we are concerned about the public safety. I conclude by saying that I specifically believe that this legislation warrants additional exceptions to make sure that we are protecting the safety of our public. With that, I yield back.
Thank you very much. Mr. Johnson, welcome.
Thank you, Mr.
Gentleman's
Chairman.
recognized.
Thank you. Good to be here, Mr. Chairman. I want to speak in opposition to H.R. 527, the Small Business Regulatory Flexibility Improvements Act, and ask that the committee make in order my amendment, which would exempt from H.R. 527 all rules that the Office of Management and Budget determines would result in net job creation. I oppose H.R. 527, which would paralyze agency rulemaking through unworkable, complex requirements without creating a single job or helping one single family. H.R. 527 would allow for large regulated industries to manipulate the regulatory system in their favor while delaying or blocking critical safeguards to protect our nation's food supply, environment, and workforce. The American, excuse me, the American Sustainable Business Council, a coalition of partner organizations representing over 200,000 businesses, opposes the legislation precisely because it would allow for the largest firms to further dominate the marketplace through erosion of our nation's regulatory. In other words, H.R. 527 is a thinly veiled handout to the nation's largest corporations. The majority has repeatedly argued that regulations undermine job growth and burden American families. But the only evidence supporting that outlandish claim has been roundly debunked by the nonpartisan Congressional Research Service, which found that the study's cost figures were cherry-picked, inaccurate, based on evidence from decades ago, and without contemporary value. The Washington Post awarded these same figures to Pinocchios on January 14th of this year, arguing that the report suffered from serious methodological problems. Even the President of the United States Chamber of Commerce acknowledged that the figures used to generate anti-regulatory rhetoric include many necessary regulations that are, quote, important for the economy, end quote, supported by the Chamber. Meanwhile, studies by both the San Francisco and New York Federal Reserve found that there is zero correlation between job growth and regulations, and that there is no evidence showing that increased regulations and taxes have any effect on the unemployment rate. Under President Obama, our economy is growing and creating jobs at its fastest pace in years on the back of sound economic policy and sensible. Mr. Chairman, my amendment is critical to ensuring that a regulatory or a deregulatory train wreck like H.R. 527 doesn't undermine this economic growth. Americans work harder than ever thanks to corporations maximizing profits through a streamlined workforce. The same corporations that are continuing to show record profit margins are also pushing deregulation and fewer taxes due to what Henry Blodgett, the CEO of Business Insider, calls a myopic obsession with short-term profits at the expense of long-term value creation. It is also clear that despite incredible growth on the back of immense workplace productivity, wages are stagnant. We need to fix that, and deregulation won't do it. Last Congress, Republicans blocked Democratic legislation that would increase the federal wage by less than $3, lifting countless full-time workers out of poverty while saving the federal government trillions in annual safety net costs. We need real solutions like legislation to address wages, not a handout to the same corporations that are already turning record profits. I ask that my amendment be made in order to protect jobs, and I yield back the balance of my time.
Mr. Johnson, thank you very much. I've got, I think, one question. For you, sir, what is the African-American unemployment rate today in America?
It's higher than it should be. It's higher than the national average, which is below 6%, I'm glad to report. It's actually getting close to 5% now. The African-American rate of unemployment is always in excess of that amount. And I think if we, I don't think this legislation will have any impact on that. Unfortunately, it probably, if it did, it would have the opposite effect, not of reducing unemployment in the African-American community, which I would advance the argument that has profited generally from government protection, rules that protect minority communities from workplace discrimination. That's one set of rules that would be impacted by, or the promulgation of rules to protect those protected classes of individuals would also be hurt by the passage of H.R. 527. And I'm glad that the chairman raised.
I think every member up here is disturbed by unemployment that we still have. On one hand, we heard how great the economics of the country are, all these 11 million jobs. That's, by the way, that's a gross, not a net figure. Not a net figure. And secondly, that we don't look at what kind of jobs they are. They're part-time jobs. They're jobs that cannot necessarily sustain themselves. So I'm going to keep a good focus on this too. I think every single one of us should tout what we believe works. I wholeheartedly agree with that, but I think that many sectors, many people all across this country are still in trouble. And on one hand, I hear people tout how great things are, and then I hear how people are going from problems to worse problems, and it doesn't seem like there's an end in sight. So I think that what we're seeing here, at least my party, is trying to address what we see as systemic unemployment, and the jobs that are created are part-time jobs as opposed to long-time jobs. I just finished a pretty in-depth meeting with a group of people from Dallas, Texas, and they were talking about how skill sets are not matching the jobs that are available. Skill sets are not matching jobs that are available, and the need for people to, as compared to, let's say, 15 years ago, we were not in such a specialized environment of needing to understand either reading levels, being able to really pass a drug test, and being able to understand computer literate skills seem to be three of the biggest impediments against for a job. And we are, there will be an announcement back in Dallas on or about April 9th, where a great big report will be issued about the mismatches, and I hope to bring back that information not only to the gentleman from Ohio for his committee, but to bring leading-edge testimony from really a place that's got a reasonably good economy, and that is Dallas, Texas, where we've had a huge number of people move to North Texas in the last few years. Of course, Texas is the job capital of America, has been for the last 5 years, and presumptively could continue, but we're still not matching people with skill sets to jobs that are available. I want to compliment the authors of the bill for taking time to try and get closer. Mrs. Fox?
Thank you, Mr. Chairman. I thank our for being here today and presenting a really good bill. I have no questions, and I yield back.
Gentlewoman, just back time. The gentlewoman from 10 feet of snow, well, I know you're from New York, but 10 feet of snow, New York.
I've got to tell you, the reason our plane couldn't take off yesterday, they told me this at the airport this morning, was that the plane was in Detroit, and it thawed up some during the day, and there was 6 inches of water around the plane wheels, and they froze overnight, and they could not move the plane. But we do have trenches on sidewalks that are 4 feet deep.
Yeah.
And when I got here today and looked outside the door, I mean, it's like a whole other world. I can't tell you what, it's absolutely awful up there. But I have no questions, and thank you. I'm glad to be back.
I've got a question for you.
All right.
Where were you born?
I was born in Harlan County, Kentucky.
Harlan
Lynch.
County, Kentucky. You need to
Totally owned by U.S. Steel.
you need to tell Joe Barton.
Don't do
He
that.
tried to claim you as a
Yeah,
Texan
we
the
went
other
through
day.
all that, and we had the pies and everything.
I know we want another
Joe's been
pie.
my friend forever. If he wants to think I'm from Texas, it's okay
We
with
want
me.
another pie.
Oh, all right.
That's
Everybody-
the
Now, the
net
new
of
people
this.
don't understand it, but Joe's always thought I was from Texas, and I don't want to say that. They made me bring pies down here and promised not to tell. You didn't, did you?
I haven't told a thing, but I would.
He's never said anything.
I just want you to know Joe's still after that.
All right, well, rhubarb's coming in, then pretty soon we'll have
there
a
you go.
pie. But just don't tell Joe. We've been here all these years, and he really believes I'm from Texas.
He still does. We missed you.
Thank you.
Glad you're back.
Thank you. Glad to
Mr.
be-
Chairman?
I don't want to try and compete with any of that, so I think I'll just confine myself to thanking the authors for a very good bill. You know, when I travel my district, I probably hear more concern and complaint about regulation from business people that I'm privileged to represent than I do anything else. I'm more concerned about that than taxes and a lot of the other issues. They just see this as a continuing challenge to their businesses. So thank you for, again, bringing this forward. I thought it was a good piece of legislation last year, and I still hold that opinion. So yield back, Mr. Chairman.
Gentleman yields back his time. Gentleman from Massachusetts recognized.
And notwithstanding my accent, I wasn't born in Texas either, so.
And none of your exes live in Texas either.
But let me just say, thank you for coming. I hope that we have a process that allows for there to be amendments to be offered, and I'll certainly support that in the committee, and I have no questions.
Gentleman yields back his time. Gentleman from, does not seek time. Gentleman from Florida does not seek time. Mr. Stivers?
I just want to thank the gentleman from Ohio for his bill, and I want to thank all the members for their passionate testimony and their support of small business. I think this is a fine bill, and I appreciate the gentleman's efforts on it and look forward to moving it forward. Yield back the balance of my time, Mr. Chairman.
Gentleman yields back his time. Gentleman from Georgia?
Request time.
Gentleman does not have any questions. I'm going to thank all four of you for taking time to be here today. In fact, this committee counts on you to come up before this committee and not only speak your mind, as you know. I've tried to make sure everybody feels welcome up here, and you have lived up to the axiom to be done well enough to be invited back. So I thank both of you, all four of you, for being here today, and thank you very much. The committee is now searching for what we believe is two members who would offer testimony of H.R. 50, Unfunded Mandates, Information and Transparency Act of 2015. And so we're searching the hall. Sarah is out searching right now as we speak. Watch her. There she goes.
So, Mr. Chairman, did the ranking member, did she say Harlan, Kentucky?
Yep,
Harlan County, Kentucky?
Harlan County.
One of my shows that I enjoy a great deal now portrays that, probably not in the best way, but Justified. A lot of folks we deal with in our intellectual property with movies and TV portray that very well. So it's an interesting time, but when you said that was pretty cool.
I left there when I was 5, but
Yeah.
remember it pretty clearly.
That's pretty cool. That's neat place.
I have been advised that our Republican and Democrat colleagues who would be giving testimony are well on their way. If somebody has newer information or better information or different information, appreciate you letting us know, but we'll take a recess for 10 minutes. Committee will come to order, and thank you for allowing us to wait a few minutes. We had taken a 10-minute delay, and we now see where we're joined by the young chairman of the Government Reform Committee and his wonderful sidekick gentleman from North Carolina, Mr. Meadows. We have previously spoken well of you and introduced you. I also understand that gentleman Lacey Clay from the state of Missouri will be here, and at the time that Mr. Clay arrives, we will welcome him. Obviously, both of you, the way we operate up here, we're delighted that you're here. You represent important ideas about jobs and job creation. I understand you all are Republicans, but this will be a very important opportunity for Democrats to present their viewpoint. And lastly, anything you have in writing, we'd appreciate you making that available and summarizing as you choose. Without objection, anything you have in writing will be entered in the record. Gentlemen, the young chairman is now recognized.
I thank the chairman and appreciate this opportunity, and thank you for the extra time to be here. We needed those few extra minutes, so thank you. I really appreciate the good work of your vice chair, Ms. Fox. This is a good bill. It's a bill that we had the opportunity to mark up. We had good debate in committee, and so I do appreciate holding this hearing and request a structured rule for the consideration of H.R. 50, the Unfunded Mandates Information and Transparency Act of 2015. Again, the primary sponsor of which is Dr. Virginia Fox. H.R. 50, the Unfunded Mandates Information and Transparency Act, is bipartisan legislation to update the Unfunded Mandates Reform Act of 1995. We've learned things since then, and this is a good bill. When enacted, UMRA was an important new step to identify and better analyze the potential burdens of legislation and regulatory mandates. However, in practice, many burdensome unfunded mandates continue to slip through the cracks due to loopholes or insufficient analysis. And by closing those loopholes and requirement in UMRA, H.R. 50 enhances the transparency and accountability with respect to regulatory and legislative mandates. My subcommittee chairman on the Oversight and Government Reform Committee is Mr. Meadows, and I'd like to, Mr. Chairman, yield some time to him to go into a little bit more detail.
Is the gentleman through with his testimony?
Yes.
I thank the gentleman very much. We will now defer to the gentleman from North Carolina. The gentleman is recognized.
Thank you, Mr. Chairman. It's a pleasure to be here. I thank the chairman of the full committee, Mr. Chaffetz, for bringing this legislation up. We had debate the other day in committee and went through markup as we addressed this particular piece of legislation in full. As we look at this, H.R. 50 goes beyond and requires independent regulatory agencies to comply with UMRA. Mr. Clay?
Mr. Clay, we're going to welcome you to this table, and we're delighted that you're here.
Thank you, Chairman. And as we look at H.R. 50, it actually codifies some of the principles that were outlined in the executive order issued by President Clinton originally, which looked at not only a cost-benefit analysis, and it reaffirms the executive order issued by President Obama, which looks at these particular issues in terms of the impact on local communities and local governments as it relates to federal regulations and go unfunded from our standpoint. And so H.R. 50 actually closed the loopholes there, allows UMRA to do a further analysis as they look at proposed lawmaking. And this is important because the GAO reports that 35% of all major rules are issued without notice of proposed rulemaking. And so when we start to look at this particular issue, if you look at some 850 major rules, and those major rules being ones that have had an impact of over $100 million or more, so we're talking about significant money, less than a quarter of those are actually going through the cost-benefit analysis. And so what we do is we pass legislation here that gets passed down to state and local governments, and those state and local governments actually have to bear the cost there. So it is an edict that comes from here and yet goes unfunded. So let me go on a little bit further, because as we look at this, there is already a provision in UMRA to consult with state and local and tribal governments. And this extends that further, looking to small businesses and the private sector who many of them actually have the burden themselves placed on them, affecting families, affecting jobs. And when you really talk about the federal mandates, Fox indeed has identified this in this particular legislation. This is all about jobs and the people back home. This is about making sure that what we do here does not impact them in a meaningful way without at least considering the cost. And so I put before this committee, as we start to look at this, as a common sense approach that deals with this. H.R. 50 allows both the chairman and the ranking member of the congressional committees to request the CBO to conduct the assessment, to go forward from an authorized level of funding in a bill or resolution, and to look at that retrospectively as well, because it changes behavior, it changes what we do, and we must address that. It also needs to look at the direct cost, certainly the foregone profits, costs that are passed on consumers, behavioral changes, et cetera. But requiring these and doing these cost estimates by CPO like a reasonable response, Mr. Chairman, and what we need to be addressing. And I will yield back at this time, but I'll be glad to answer any specific questions that the committee may have.
Thank the gentleman very much for his testimony and summary of that, which was very well achieved. Mr. Clay, welcome. I'm delighted that you're with us. Obviously, we want you to pull that up, make sure that green light's on. Gentleman's recognized.
Thank you so much, Chairman Sessions, as well as Ranking Member Slaughter and the other members of this, for allowing me to testify today on H.R. 50. You have seen this bill come through this committee 3 times before. It was a bad idea then, and this is a bad idea now. One significant difference this time around is that the CBO estimates that this bill will cost an estimated $18 million in direct spending over 10 years. That means this bill is subject to pay-go procedures and would require an offset. This bill will impose numerous new requirements that will slow down the regulatory process and give regulated industry an unfair advantage over ordinary Americans when new rules are made. Under this bill, agencies would be required to consult with impacted entities in the private sector on a proposed rule before the rule is even made available to the public. Agencies should consult with industry on proposed rules. Regulated corporations, however, should never be given an explicit and unfair preference over other stakeholders, particularly American families and consumers, that the rules are designed to protect. Manufacturers of window blinds should not get to weigh in on a rule to protect children from being strangled by a window cord before safety experts provide their recommendations, or before the parents of children who have been strangled to death get to provide their perspective. This bill would also significantly expand judicial review under the Unfunded Mandates Act. UMRA currently prohibits a court from delaying or invalidating a rule based on an agency's compliance with UMRA. This bill would eliminate that restriction. The bill would also allow judges to second-guess agency experts by evaluating the adequacy of agency analysis, including cost-benefit estimates. So, for example, a bank could use UMRA to challenge a rule by the CFPB that protects consumers from abusive mortgage practices. H.R. 50 would also repeal the exemption that is currently in UMRA for independent agencies. As a result, the independence of agencies like the SEC and the CF and the Consumer Product Safety Commission could be compromised because the Office of Management and Budget would now have a role in shaping the rules those agencies issue. I also urge the committee to adopt an open rule for H.R. 50. If the committee instead chooses to adopt a structured rule, I would ask that the committee make the amendments of Mr. Connolly which he submitted in order. And Mr. Connolly's amendment would sunset the reforms made by this bill if the average annual rate of domestic product remains below 5% over the first year following enactment. Mr. Chairman, I'd also request that the amendment that Oversight Committee Ranking Member Cummings submitted to strike Section 12 of the bill be made in order. Section 12 would require an agency to conduct a retrospective cost-benefit analysis of any existing rule if requested by the chairman or the ranking member of the committee. The bottom line is that regulations make our air cleaner, our water safer to drink, the products we use safer, and provide protections that are critical for a healthy economy. H.R. 50 would impose new roadblocks that would make it harder for agencies to provide these protections. And, Mr. Chairman, I thank you again for your indulgence, and I will stop there.
Mr. Clay, thank you very much. I'm delighted that all three of you are here, and in fact, I was just looking at what is the Congressional Budget Office report, and it talks in here about federal agencies produce between 3,000 to 4,000 final rules a year. And of course, I know we've heard somebody believes there's no rule that they haven't seen that ever hurt a job or job creation. That must be somebody that's locked up in a cave somewhere, but I'm delighted that you're here, and I have no clue who wrote this bill, but I think they did a darn good job. Mrs. Fox, you want to defend yourself?
Thank you, Mr. Chairman. Well, I have to say that from the time I was in the state Senate, I have been concerned about unnecessary rules and regulations. And Mr. Clay, I like you a lot, but to say we're anti-regulations is really unfair. Republicans are not anti-regulations. We want regulations. We need regulations. We want safe food. We want safe products. We want safe cars. We're not anti-regulations. But I think my colleague from New York said this is a common sense approach. I think we pride ourselves in North Carolina, I think, with having a lot of common sense. And what this does is say we're going to abide by UMRA, which was passed in 1995, I think almost unanimously by both Democrats and Republicans. As you said, this bill has passed 3 times before, always with bipartisan support. So this is not a bill that is crafted by wily Republicans to get rid of rules and regulations. It is to bring some common sense to the process. What's happened over the years is bureaucrats don't want to do their jobs, and they don't want to be held accountable. And so they have found ways to get around the original UMRA bill. It has not been revised since 1995. That's a mighty long time for legislation on the books and for bureaucrats to be able to find ways to get around the rules. So what we want to do is make sure that the agencies and the public know the true cost of the rules and regulations that are being imposed on the American people. And as the chairman said, this is legislation it's a jobs legislation. It is a bill that us to make sure we're not quashing jobs in this country or stopping jobs from being created by unnecessary rules and regulations. And Mr. Chairman, I would love to take all the credit in the world for this bill. And as I said, I've had a lot of interest in the subject over the years, but I have a wonderful staff who come up with great ideas all the time. And I think and I have lots of constituents who come up with great ideas. So a combination of constituents and staff and my own interest in this is what's created this legislation. And I'm delighted with my Democrat colleagues who've signed on as original co-sponsors, as co-sponsors of the bill, and for those who voted for the bill in the last 3 years, the last 3 times it passed. So we just are filling in some loopholes that people have found in the original legislation. And I don't think that's a bad thing to be doing. Let's let our agencies be transparent. If the rules that they are proposing are common sense rules, and if they don't put a big burden in terms of cost on the public, and they can prove that the cost-benefit analysis is appropriate, then I think those are going to pass. It's, again, not an anti-regulation bill at all. And I'm disappointed to hear you imply that that's what it is. I'm proud of this bill. I'm proud of everybody who supported it in the past. And I thank the chairman of the committee and my colleague from North Carolina again for putting the bill through the subcommittee and the committee and having a hearing on it so that we are back to regular order in the way that all of us want to be, but also point out that this bill's been through a lot in the last 4 sessions. So thank you, Mr. Chairman. I yield back.
Chairman, may I respond to Ms. Fox? Because I do appreciate.
In fact, I would allow that time.
Thank you. And I do appreciate your friendship and your service to this nation. However, in this instance, when you think about how we may jeopardize safety to the public, I can point to one example that this country is going through right now. And if this bill were to become law, it would exacerbate that situation, and that's with the exploding airbags that we find American consumers coming up against. I mean, I just read about a recent death over the weekend of these defective airbags that Toyota and the makers have refused to replace in the automobiles. And if we were to allow the manufacturers and the automakers to weigh in before the public has a chance and before experts have a chance to look at these products, it would just multiply the difficulties that we would face as a country with defective products. And so, you know, I'm thinking that legislation like this would open the gates to allow more and more defective products to get on the market, and that is one of my concerns, Ms. Fox.
Would the gentleman wish time? Would the gentlewoman wish time?
Yes, sir, I do.
Gentlewoman's right.
Thank you. And I think my colleague from North Carolina also wants to speak. But, Mr. Clay, this bill provides for emergency rules to be developed in any situation that occurs where we need an emergency rule. As I said, this is not an anti-regulation bill. So if there is a need for emergency rules, the opportunity is there. However, what's been happening in the past is emergency rules are written and then the agencies never go back and do their due diligence as they're supposed to do. And that's one of the loopholes that the agencies have used. So again, let's be honest about this. We do not take away the opportunity for emergency rules to be written, but we're going to do our best to keep the agencies honest. And 6 months later, they're asked to come back and provide the justification. That isn't too much to ask. Thank you, Mr. Chairman. The gentleman from
I get that, but I did not know if you wanted to use the time that allocated you, so I will defer to the gentleman who evidently wants to make a statement. Gentleman's recognized.
Well, thank you, Mr. Chairman, and I want to follow up on what the Vice Chair, Dr. Fox, was saying, is certainly within this, there are those areas for emergency rulings for faking that can be made, but I want to also point out to the gentleman, the distinguished gentleman to my right, that this is a consumer, the scenario that he puts forth is a consumer safety defect and not an unfunded mandate issue. It does not preclude us from following up on defective products or anything like that. This talks about the implementation of unfunded mandates. And to suggest that we have an airbag problem that we can't go after from a defective manufacturer's point of view is not under the purview of the underlying bill. And so to suggest that that's a problem that Dr. Fox is not addressing is not germane to the issue. And so I just wanted to point that out, Mr. Chairman. I thank you for your time.
Thank the gentleman. I think we've cleared the air now. Thank you very much. Does anyone want to seek time?
I just have one thing I'd like to
Sure,
ask
right
Mr.
now.
Clay. Thank you very much. Mr. Clay, it's come to increases direct spending, violates the cut-go rule. If that's correct, would you say that the Rules Committee also doesn't want to comply with the rules?
I would. Well,
fair
I mean, that's what CBO tells me. CBO estimates that the new requirements placed on independent agencies alone would cost $18 million
Wow.
in direct spending over 10 years. CBO also expects independent agencies would increase fees to offset the cost of implementing the additional regulatory activity. The bill violates cut-go because it does not include an offset.
I think I read the other day to one of the smaller business groups, and I'm sorry, I shouldn't bring it up if I can't recall the name of it, but I can't, but had asked that Mr. Shabbat's bill be withdrawn because of the unfair advantage for major corporations at their expense. Are you aware of that?
Yeah, and I think this bill goes down that same path. When you look at that it allows small business to have the first shot at any proposed rules, I think it takes us down a slippery slope.
Well, I hope that the amendments that you mentioned that needed to be made in order will be made in order.
And that's were offered in good faith.
I think so.
I would hope that the
because of the
chairman and
authors,
all members of the committee would consider that.
Yes. All right. Yield back.
Thank you, gentleman. Gentleman from Oklahoma recognized.
Thank you, Mr. Chairman. Just a couple quick points. I must say that my good friend, the gentlelady from North Carolina, nearly lost my vote when she said the bill wasn't crafted by wily Republicans to get rid of rules and regulations. I thought, why not? Isn't that why we made Republicans? I thought that was it, but I still like the bill. I do want to ask my friend from North Carolina one point, and I may not have understood this in your testimony. I think you mentioned tribal governments in the course of your remarks. Did I hear that correctly?
Thank you. As you know, you and I share a passion for our tribal government.
I was going to mention my friend represents one of the greatest tribes in this country, the Eastern Band of Cherokee.
I was talking to them today, and so much of the assistance already deals with some of the state, local, and tribal governments, and so it's not meant to preclude them or put them in any kind of a disadvantage. Mr. Cole and I would not stand for that. In this particular, it adds a group of protected entities, the private sector, that would include individuals, associations, a number of others that sometimes tribal governments have associations with, but one that I was clear with that, and it does not undermine any authority.
Well, I appreciate it, because this is, you touch on, as you know, frankly, one of the great problems that tribal governments have, which is they do live on their own land under a federal regulatory regime. And we see this over and over again where states are free to, I can just tell you on drilling, for instance, and mineral rights issues, to have their own regulatory regime. And quite often, you'll see exploration, North Dakota is a good example, right up to the edge of a reservation that's much more difficult, because it's more expensive, more time-consuming. You know, we see tribes that, you know, for many years were not regulated by the National Labor Relations Board. They unilaterally took that authority in 2004 and placed them under there, even though, again, they're governments, and state and national governments are not under the Labor Relations Board. So I'm glad that you just mentioned it to give me an opportunity to point that out. This is an area rife with the need for work in order to, and we've made some good progress here on a bipartisan basis. Our friend now, Senator Heinrich, was in Representative Heinrich. He brought some really great legislation called the Hearth Amendment, which gave tribes the ability to manage their own property better. We get a federally approved regime over their property management, and then they would actually do the management. You wouldn't have to send every land decision all the way to the Secretary of the Interior for approval in an impossible situation. So, again, I appreciate my friends working this. I really appreciate my friend's bill because, again, as I said, from the businessmen and women that I represent, and I suspect it's true of me, I hear more about regulatory problems than anything else. And it's not that they're not concerned about taxes or they're not concerned about health care proposals or whatever they are, but, you know, getting at these kinds of issues to make, again, as my friend Ms. Fox said, nobody wants to get it. We all want to drive safe cars and eat good food, but the appropriate balance seems to have gone too heavily in the federal direction, and it's just the amount of time that it takes to comply, the micromanagement from Washington, D.C. is just truly tremendous, and the cost that is offloaded from the public sector onto the private sector is tremendous. So I want to commend my friend from North Carolina, who is a wily Republican, but I also want to thank you, gentlemen, for bringing this legislation forward through the process. Yield back.
I thank the gentleman. Does the gentlewoman intend to defend herself against the claim of a wily Republican, or does the gentlewoman accept that
I've been called worse.
accusation?
And that's by other Republicans.
And there's a, does any Democrat seek the gentleman from Massachusetts recognized?
So we have considered this, what, 3 times before? So this is the 4th time? So this is one of the oldies but goodies that is coming back, one of the retreads. You know, when I look at this bill, I mean, when I read it, it seems to me to be yet another assault on public health and public safety and environmental protections. And, you know, and I know, you know, you obviously have a different position on it, but I'm not convinced that this bill, the 4th time around, has any better chance of becoming law as it did the first 3 times around. I think the administration in the last go-around had issued a veto threat against this. You know, maybe you get the Senate to take it up. I don't know. But again, it goes to kind of a larger point that it seems to me that, you know, if we're all worried about the economy and we're all worried about the middle class, we ought to be trying to figure out a way, you know, to raise people's wages, to help people have more opportunities. We ought to be discussing a highway bill. We have roads and bridges that are crumbling all across this country. I have bridges in my state that are older than most of your states, and they desperately need attention. And when I go home and I talk to my small businesses and my small manufacturers, you know, they talk about, you know, the lack of a skilled and well-trained workforce. They talk about the need for a better infrastructure. They talk about, you know, a whole bunch of other things. And, you know, I think a lot of them would love to, you know, some of them, I think, you know, are not terribly thrilled that you have to comply with regulations. But the fact of the matter is how much that needs to be done that I think there might even be bipartisan consensus and buy-in from the White House to actually accomplish something that, you know, I just can't help but think that, you know, we ought to be doing that than this. And so, you know, I have no questions. Thank you all for being here, and I guess we'll see you on the floor. And I hope, by the way, that we have as open process as possible, because I do think, you know, at some point we have to start giving members the ability to amend things on the House floor. So I thank you, and I yield back my time.
Gentleman yields back his time. Does any other Democrat seek time? The gentleman's recognized.
Yeah, very briefly, Mr. Chairman, was just informed that staff of the administration would recommend to the president a veto, and we'll have a hard copy for you. We just were informed.
Appreciate that. As soon as
Here,
the SAP arrives,
I ask
I'm sure
unanimous
that
consent
without
to be made a
objection.
part of the record.
Mr. Post, do you seek time? Gentleman does not seek time. Does any Republican seek time on the bill? Gentleman, George is recognized.
Thank you, Mr. Chairman.
Yes, sir.
I just happen to have school board in from my largest county. I only represent 2 counties. The big one, Gwinnett County, won the Broad Prize again this year for the best urban education school district in the nation. They won it 4 years ago, and then they had to sit it out for 3 years. This was the first year they were re-eligible, and they won it. School board sitting in my office, and they don't want to talk about No Child Left Behind. They don't want to talk about how to educate children, because they know how to educate children. That's why they're so successful. They want to talk about IDEA and why it is the federal government passed a statute, promised to pay for it, and never came up with the money to do it. Folks who are in the business of loving children and making them successful, doing it so well that they get recognized nationally year after year, want to know why the federal government is part of the problem instead of part of the solution. And I want to ask my friend from North Carolina, because he comes from, well, my friend from Utah too, come from places with great public lands, great private lands, environment. My friend from Massachusetts said if we pass this bill today, it's going to threaten environmental regulations. It's going to threaten opportunities to succeed. I just want to ask: is there any suspicion at all in your minds, as folks who come from districts where the men and women pride themselves on environmental stewardship, that the passage of this bill would lead to degradation in any way?
If I may, I think the title of this bill is very appropriate. Unfunded Mandates, Information and Transparency Act. You know, there's probably nothing more offensive than having something mandated upon you with no funding behind it and no explanation, no input, no ability to comment, not hearing about it ahead of time. What are we afraid of? We're just trying to ask that they be part of the process, the people that actually get affected by this bill, that they actually be asked for some input.
Well, when I heard Mr. Clay talk, I started to get concerned before it shows up on the desk, and Mr. Clay is talking about putting big business first in these conversations. I'm thinking that kind of offends me, because for Pete's sakes, I represent the little guy in my district. Why in the world is big business going to get the first seat at the table? So, knowing Ms. Fox as I do, I thought that doesn't sound like something Ms. Fox would propose. I went back and I pulled the bill to see if I missed it, and what the language would actually say. Current law says each agency, to the extent permitted in law, shall develop an effective process to permit elective officers of state, local, and tribal governments or their designated employees with the authority to act on their behalf. And Ms. Fox's language would add, and the impacted parties within the private sector. That's kind of radical. I'm thinking about the window blinds issue that Mr. Clay brought up. I mean, we're going to bring in the lawyers from the local governments. We're going to bring in the lawyers from the state governments. We're going to bring in the lawyers from the tribes. And what Ms. Fox is proposing is that we also bring in the engineers from the window blinds manufacturers if what we really want to do is produce a better and safer window blind. Now, is there any kind of Trump power that is implicit in this language, or are we only saying that if the lawyers are going to have a seat at the table, we should give the engineers a seat at the table as well? Mr. Clay, do you understand that language?
Let me try to respond. Currently, agencies are already required to take into account the cost to private sector interests in rulemaking under UMRA. And if the proposed rule will cost over $100 million, then anyone, any interest group can also on a rule during the public comment period. So, I mean, under this, you're kind of giving them priority.
Now, if that's true, I'm going to be a lot less excited about this piece of legislation, because the way I understand it, and this used to be original Rules Committee jurisdiction back in the day, 1995, it almost offends me that folks think we didn't get it right the first time, but having read the language, I see there is a way
The
to
Rules Committee was
improve it.
legislating?
We have a little original jurisdiction around here. We don't get to roll it out very often, but we do. What I read in this bill is that what we've done is taken care of those intergovernmental mandates that are up over $100 million. But what this bill does is expands it to say if you're going after any mandate, it ought to be part of the question. Because to Mr. McGovern's point about the middle class, I read article after article. You all have to read them too. That say for every dime gas prices go down, it's like $1 billion in stimulus for the country. So I have to go up. But if the price of their window blinds are going up at the same time, they get nothing. If we have a way that we can protect safety and protect the price of their goods, and again, Mr. Meadows, if I'm wrong, I want somebody to tell me that I'm wrong, because I don't want big business at the table first. What I do want are folks who understand an industry and can achieve our regulatory goals of safety and certainty for working families, can achieve those goals in the way they're going to cost those working families the least, whether we're talking about higher taxes or whether we're talking about higher prices for the jungle gym that they want to put in their backyard for the kids.
Well, Mr. Woodall, I would just say thank you for your question. I would have the same concern. I was a small business guy, and if I thought that I was going to give major corporations the upper hand, it would be very difficult. But outside of most small businesses is a small little plaque called NFIB. And that stands for the National Federation of Independent Business. Most of them mom and pops, like I was. They support this legislation. You know, and what better endorsement can you get from those who stand up? They're in the business of protecting small businesses, and they support the legislation because they see the impact, Mr. Woodall, on a regular basis of these regulations. And my esteemed colleague to my right here, talking about how covered in, you know, the existing legislation, it really is not. That's part of what Dr. Fox has done is gotten a lot of these independent regulatory agencies to be included in that. And history, facts are a stubborn thing. Out of 850, in my opening testimony, out of 850 major regulations costing over $100 million, 3/4 of them did not go through the cost-benefit analysis. So more information is better, and I appreciate you bringing that up.
May I, Mr. Woodall, just in response to your comments, I think the trick here is to be able to strike the proper balance between industry and entrepreneurship and creating the best mousetrap to also ensuring safety for American consumers. And so if we strike the correct balance with this legislation, and I'm not certain that this takes us where we want to go. If we want to ensure product safety for all American families versus entrepreneurship, I'm not sure if the unfunded mandate bill does.
I think that's a fair concern. It's a concern I share. And I hope that the committee is going to work together to try to make this process as open as it can be to try to improve upon that bill. If what we've done is a good thing, if dealing with unfunded mandates is a good thing, and yet we're only dealing with about 25% of those regulations, that's probably not the right balance either, letting 75% of these things which we decided needed to be regulated, for lack of a better word. If we're just, that can't be the right balance either. If we didn't get it right here, I hope we'll be able to make some of these amendments in order and get it right on the floor. But I get it right if we're not moving this legislation forward. I don't mind that we've seen it here before. A lot of times we see legislation here that we've seen before, and it just skips the regular order process. It speaks volumes about what's going on in the Oversight Committee this cycle, that the first pieces of legislation that show up from there have gone through the process, had the input of all the members, and have come before us. Mr. Chairman, I yield back.
for a small company called AT&T or SBC. It depends upon at what period of time that I was there, but they're the same company. But how lots of times, as a big company, we tried to work with customers before others got involved. We tried to alleviate a problem, and lots of times, just by simply talking to people, they then understood, or I understood, what their limitations or mine were going to be of how we could solve a problem. And I think it's always better to have somebody come tell you they got a problem before they complain to somebody else. And it sounds like to me that, and the way I see this is, it gives the agency an opportunity to speak with people who could perhaps solve the problems best of all. I don't believe anybody else seeks time. Oh, you do.
Mr. Chair, I just ask unanimous consent.
Jumps recognized.
Thank you. I ask unanimous consent to submit a statement of administrative policies for the other bill. 50 just came in. The second one, we now have to submit.
Without objection, we'll do that, and I thank the gentleman. Thank you very much. Appreciate your time. This now closes the hearing portion of H.R. 527, H.R. 50, and the chairman would be in receipt of a motion. Excuse me just a moment, please. Thank you very much. The staff has just advised me that as we finish up the amendments and the decisions, there are several outline questions that still have not been resolved in writing yet, and we're trying to attempt to do that right now. We note that there will be votes on the floor in about 10 minutes. So what we'd like to do is to end this hearing, recess, subject to my call, but that would be at the end of the next vote series, and we'll come back in and get our work done. Any comments or questions? Okay, thank you very much. We'll come back at the last vote, the end of the last vote. Yeah, no.
You could just hold on for about 2 minutes. Mrs. Fox staff is updating her right now.
Committee will come to order, and pending Mrs. Fox, who will be here in just one moment, I'd like to defer to the gentleman, one of our great new members from Georgia, for an introduction of some very important guests that he has. Gentleman's recognized.
Mr. Chairman, I do appreciate it. Before we get started, and again, one of the things we've been talking about was unfunded mandates. We've been talking about regulations, and today I had to come see me some dear friends of mine from Georgia, several from Hall and Dawson, my district, with the Georgia School Board Association. We've been talking about education with them, and I'd like for them that there on the row, Will and Nate, and then also my friends from Vidalia as well. But also we have another special guest who just sort of tagged along. And we talked about our singing friend the other night who was here with us. The Commissioner of Agriculture, Gary Black from the state of Georgia, is here. Gary's done some really innovative things with how to work around regulations and also work with getting homegrown foods to our schools and work with that, and also has one of the best singing voices from Northeast Georgia. I just am so proud of them for being here, and I just want to take time to let the committee know how proud I was and also what they do in the state of Georgia. We appreciate a bunch.
Well, I want to welcome, and I thank the gentleman very much. Did we bring the onions? Who's from Vidalia? Well, we're going to be ready for onions. We as a committee typically are up here for long hours, and we, by and large, get along real well. We enjoy eating each other's pie and cake and cookies and nuts and pecan pie and occasionally rhubarb pie. I don't think that Louise makes that for the Democrats, but she makes rhubarb for us. Maybe does she share that with you guys? No, really. No, that's and Mr. Hastings thinks a rhubarb is a fight at a baseball game. and well, all right, peach pie. So there's any number of great things, but to have a Commissioner of Agriculture here, I called our ambassador, used to be a guy named Todd Staples from Texas, and he was really an ambassador for us, and I'm sure, Commissioner, you are also. We're just delighted that you're here. Now, this is Virginia Fox, and Virginia Fox is the most educated of all members. She's known as Dr. Fox, but this is the school board of the state, Georgia School Board Association, and so you're looking at education in its finest form, and I want to thank you and thank you all for visiting very, very much. We hope we do well enough where you want to come back, but it's to be seen, so we'll see what happens. The chairman will now be in receipt of a motion from the gentlewoman from Grandfather Community, North Carolina, the vice chairman of the committee, Mrs. Fox.
Thank you, Mr. Chairman. I move the committee grant H.R. 527, the Small Business Regulatory Flexibility Improvements Act of 2015, a structured rule. The rule provides 1 hour general debate with 40 minutes equally divided and controlled by the chair and ranking minority member of the Committee on Judiciary, and 20 minutes equally divided and controlled by the chair and ranking minority member of the Committee on Small Business. The rule waives all points of order against consideration of the bill. The rule makes an order as original text for the purpose of an amendment in the nature of a substitute consisting of the text of Rules Committee Print 114-3, and it provides it shall be considered as read. The rule waives all points of order against that amendment in the nature of a substitute. The rule makes an order only those further amendments printed in Part A of the Rules Committee report. Each such amendment may be offered only in the order printed in the report, may be offered only by a member designated in the report, shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and an opponent, shall not be subject to amendment, shall not be subject to a demand for division of the question. The rule waives all points of order against the amendments printed in Part A of the report. The rule provides one motion to recommit with or without instructions. Section 2 of the rule provides for consideration of H.R. 50, Unfunded Mandates Information Transparency Act of 2015. Under a structured rule, the rule provides 1 hour general debate, equally divided and controlled by the chair and ranking minority member of the Committee on Oversight and Government Reform. The rule waives all points of order against consideration of the bill. The rule provides that an amendment in the nature of a substitute consisting of the text of Rules Committee Print 114-4, modified by the amendment printed in Part B of the Rules Committee report, shall be considered as adopted, and the bill as amended shall be considered as read. Rule waives all points of order against provisions in the bill as amended. Rule makes in order only those further amendments printed in Part C of the Rules Committee report. Each such amendment may be offered only in the order printed in the report, may be offered only by a member designated in the report, shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and an opponent, shall not be subject to amendment, and shall not be subject to a demand for division of the question. The rule waives all points of order against the amendment printed in Part C of the report. Finally, the rule provides one motion to recommit with or without instructions.
You've now heard the motion from the gentlewoman from North Carolina. Is there discussion or amendment to that?
Mr. Chairman,
Gentleman's recognized.
I have an amendment to the rule. I move the committee grant H.R. 50 and H.R. 527 each an open rule so that all members have the opportunity to offer amendments to the bills on the floor.
Discussion. You've now heard the McGovern amendment. Those in favor signify by saying aye.
Aye.
Those opposed, no. No. Noes have it, noes
Ask for a
have it.
roll call, Mr.
Gentleman asks for a roll call vote.
Ms. Fox? No. Ms. Fox? No. Mr. Cole? Mr. Woodall? No. Mr. Woodall? No. Mr. Burgess? No. Mr. Burgess? No. Mr. Stivers? Mr. Stivers? No. Mr. Collins? No. Mr. Collins? No. Ms. Slaughter? Mr. McGovern?
Aye.
Mr. McGovern, aye. Mr. Hastings?
Yes.
Mr. Hastings, aye. Mr. Polis? Mr. Chairman?
No.
Mr. Chairman, no.
Clerk will report the total.
2 yeas, 6 nays.
The amendment's not agreed to. Further amendment or discussion? Seeing none, the vote will now be on the motion from the gentlewoman from North Carolina. Those in favor signify by saying aye. Aye. Those opposed, no.
No.
The ayes have it, the ayes have it.
Ask for a roll call, Mr. Chairman.
Gentleman asks for a roll call vote.
Ms. Fox?
Aye.
Ms. Fox, aye. Mr. Cole? Mr. Woodall? Mr. Woodall, aye. Mr. Burgess? Mr. Burgess, aye. Mr. Stivers? Mr. Stivers, aye. Mr. Collins? Mr. Collins, aye. Ms. Slaughter? Mr. McGovern?
No.
Mr. McGovern, no. Mr. Hastings? Mr. Hastings, no. Mr. Polis? Mr. Chairman?
Aye.
Mr. Chairman, aye.
Clerk will report the total.
6 yeas, 2 nays.
Motion is agreed to, and the gentlewoman from North Carolina, Mrs. Fox, the committee will be handling the rule on the floor.
And Mr. Polis of Colorado will handle it for the
And
Democrats.
Mr. Polis of Colorado, I thank you very much. This has been a long meeting today, and I want to thank the staff in addition to the members for their participation today. And I want to state that at this time, we do not anticipate there will be a further Rules Committee meeting this week. So the committee is done with this work for the week.